This is Stanford Legal, where we look at the cases, questions, conflicts, and legal stories that affect us all every day. I'm Pam Karlan. Please subscribe or follow this feed on your favorite podcast app. That way, you'll have access to all our new episodes as soon as they're available. Today, I'm talking with my colleague, Jeff Fisher. Jeff's a professor of law here at Stanford and co-director of the Stanford Supreme Court Litigation Clinic. And we're going to talk about this term at the Supreme Court. It used to be, on there was an actual last day of the term, and you could be pretty sure you weren't going to hear very much more until the first Monday in October when the court came back. But I think now the court kind of stays in session year round, but they've now completed issuing opinions in all of the cases on which they heard oral argument this past term. So I guess the place to start, Jeff, is how would you characterize this term at the court?
Well, Pam, it's always great to talk with you, and I'm super excited to hear what you think about all of this as well. And as we record this, we're just digesting this morning's final batch of decisions. But I think there's two things that jump out at me on a high level about the term. One is the obvious clash between the court and President Trump over executive power. And the court issued, I guess fair to say, a mixed set of decisions on that front, which I'm sure we'll talk about. But I think that is, on the one hand, quite dramatic and unusual over the course of our nation's history to have the court and the president clashing in this way. But on the other hand, kind of expected in a world where most substantive policy now comes out of the White House instead of Congress. So, I'm sure we'll talk more about that. The other thing, though, and I wonder whether this is just getting lost a little bit more in some of the media coverage of the court because President Trump upped so much attention, is I kind of look at this term and I see in many ways the fruition of what I think of as a traditional conservative legal movement over the past 20 or 30 years. The agenda to revitalize the Second Amendment, to curb race consciousness in admissions and voting and other areas, to enhance religious liberty, to curb regulation in various ways. And so one thing I'm digesting is just how successful that movement has been with this court and wondering where it might go now with a lot of those major goals accomplished.
Yeah, I think those are two things that struck me about the term as well. The other thing that struck me about this term is there's a lot of tension among the justices. I mean, there are a lot of opinions kind of going back and forth and sniping at each other. I mean, we saw that early on in the term in the tariffs case where you had, Justice Gorsuch kind of mansplaining major questions doctrine. And you saw that in today's decision in the birthright citizenship case with the back and forth really between Justice Jackson and Justice Thomas over what the meaning of the 14th Amendment, the original meaning of the 14th Amendment is. So you're seeing, I think this is not a court on which there's a lot of consensus, and I think there's a lot of mistrust or distrust of the kind of bona fides of other members of the court in various ways, and that strikes me as different. The other thing, of course, about this term at the court is that the court had to issue a bunch of merits decisions on issues that they had kind of punted or pushed away last term, the birthright citizenship being the biggest one, but also the Lisa Cook issue and the Humphreys executor issue and the like. So a lot going on this term. I don't know. One thing that got lost, I think, in most of what I've heard of the coverage of today, which is mostly about birthright citizenship and like, is the court's major Fourth Amendment decision. And that's obviously an issue that you focused on a lot. So I wonder if you want to say a little bit about geofencing before we get into some of the stuff that people have been more focused on.
Yeah, good point. It's great to bring that case up because it's not a political case in the way so many of these others have that valence. And for that reason, I think the court is a little bit more interesting in these cases sometimes. So this case continued a path the court set down years ago in one of our own clinic cases called Riley and continued on in another case called Carpenter of basically applying the Fourth Amendment to digital devices and information, in particular location history in this particular new case. And so I think the court is now, fair to say, firmly committed to applying the Fourth Amendment in a meaningful and even robust way in the digital world, where all of our information is both kept on these devices that are readily obtainable by the government absent a warrant, and information we share with third-party providers like our cell phone service provider or Google. And so I do think it is quite significant. And the court's idea is that because of new technology, the government has a greater ability than ever to get into the intricacies of our private lives. And the court sees the purpose of the Fourth Amendment as being served by applying it in these new contexts, even if strictly speaking, the doctrine doesn't quite work. So that's kind of an interesting way to think about it. Often the court is very allergic in the statutory interpretation context and even in the constitutional context to getting behind the broader purpose of a law and trying to carry that forward in new circumstances, but it seems far less inhibited in the Fourth Amendment. And maybe that's just because the Fourth Amendment uses the loose word reasonable, but I still find it kind of interesting. And I like that the court's doing it, but I'm not sure everybody else would.
I sometimes wonder whether part of the reason the court is doing that here is they understand this because they all have cell phones, right? And so if they think to themselves, well, because I mean, the famous example of this was in the case that involved putting the locator beacon underneath the car, at which the Chief Justice said, well, if you can do this to this guy, could you put one of these devices on my car? And Michael Dreeben, who was the Deputy Solicitor General, had to say, well, yes, we could, at which moment you knew where the court was going to go.
I think that's a great point. When the court can imagine itself in the situation of one of the litigants, it's immediately a different case.
Yeah, yeah, and the Fourth Amendment is that area for them.
Especially on these issues, absolutely.
Yeah, yeah. So you had divided the court's kind of big ticket cases into two buckets, the sort of traditional conservative movement bucket and the Trump agenda, if you will, bucket. And there's a little bit of overlap between
Yep.
those two. But maybe the place to start is with the kind of traditional conservative movement docket. I mean, earlier on in the term in Louisiana against Calais, and then in the repeat of Milligan up at the Supreme Court, the Alabama case, we saw the Supreme Court has really now gotten to the point, and the campaign finance case, I think today is another example of this. They've gotten to the point where they are just not going to police the democratic process very much. They're going to leave that to the states to do. They're going to allow unlimited amounts of money to move into the political process in a bunch of ways. And it seems like they've really kind of gotten to the point where there's not much more they could be doing in these areas.
Said we're not going to police partisan gerrymandering as the other piece of right. And obviously this is your turf more than mine, so I'm more interested in your views. But it seems like I don't know what's left. I think Justice Kagan says today there's a remnant of a remnant left of campaign finance laws, and so maybe they'll go after that last little sliver of a nugget. But I think it's hard to know what's next in that category. You know, the thing that I've wondered, Pam, and maybe you want to say some words about the voting cases themselves, but I've seen some people writing about Calais and wondering whether that portends a bigger attack on disparate impact laws more generally. So maybe that would be somewhere that we might look for future challenges.
Yeah, and of course, there's just been an opinion from the Office of Legal Counsel, which is, if you kind of think about the Supreme Court of the executive branch, it issues kind of constitutional rulings within the executive branch, suggesting that all of disparate impact law is unconstitutional precisely because it's too race conscious. And, you know, do I think the court's likely to go there? It's been a major kind of piece of the conservative legal movement for quite a while now. If you go back to the 1990s and the Ricci case, it's been around this argument that, you know, I think Justice Scalia used the phrase, the evil day, you know, the evil day is coming where we have to confront all this.
Sandoval was kind of one of those cases.
Yeah, so I think, yeah, I think disparate impact theory, there are a bunch of justices who would like to get rid of it. One of the things that I think might make that difficult in a weird way for them is that Title VII, for example, which is the leading disparate impact statute, doesn't just forbid disparate impact on the basis of race, but it also forbids disparate impact on the basis of religion. And this is a court that very much wants to protect kind of religion
Yeah.
claims. And so, it'd be interesting to see how they negotiate coming up with you can't have disparate impact for race claims, but you can have it for
Right.
religion claims. I mean,
Right. And because as a constitutional matter, those two areas of law are separate, where the Smith doctrine prohibits, at least stands in the way formally of the court extending disparate impact to religion claims.
yeah.
So yeah, it's interesting how they're tied together on the statutory level. That would be interesting.
Yeah, it'll be interesting to see. But I think, one case that I don't know how much it actually surprised people was the Watson case, which is the case about whether states can count ballots that are cast and postmarked by election day, but don't arrive until after that. And that was a 5-4 decision with the three more liberal justices plus Justice Barrett writing it, and the Chief Justice. And one of the things, of course, there, and I think this is true also with the citizenship case and maybe with a couple of these other cases, is 10 years ago, they would not have been 5-4 cases.
Yeah.
10 years ago, I think it would have been close to unanimous that, of course, the states have been counting these ballots that come in after election day that are cast by mail. They've been doing this for decades, if not for 100 years with regard to, military ballots and the like. And no one had ever assumed that there was any problem with this. But in recent years, and Justice Alito's dissent in Watson really takes up Donald Trump's agenda lock, stock, and barrel of there's likely to be fraud. And I really did kind of wonder, why is there likely to be more fraud in a ballot that's postmarked by election day and arrives 2 days later than one that's postmarked by election day and arrives on election day? I was kind of mystified as to why he thought one of those was likely to be more fraudulent. But this goes back even to the voter ID cases, and they've taken a voter ID case for, proof of citizenship case
Right.
for next term already. Is this kind of rise of a kind of conservative, there must be fraud out there in the election system?
Right. Well, I'm glad you brought up this case. I think it's super interesting. It's the one case the Republican Party lost this term. And I mean that as the litigant who brought the case. I think on the fraud and angle of it, you're better positioned than I am. Perhaps the idea is once you get past election day and know how the vote is shaking out, there's a greater incentive. Who knows? But I think the two things that are interesting about that case are, one, it is a case where the Chief Justice and Justice Barrett broke from the other conservatives. And so this is, to me, is an example of a Trump case, not a Republican.
Not a traditional.
Not a traditional. Yeah, I shouldn't have said Republican, not a traditional conservative movement case. And so that's one way to notice that some members of the court seem more committed to the Trump agenda than others. And I think we see that in other cases we'll probably talk about. And then the other thing, I wonder whether you noticed this or had a reaction to it, but I thought there was a super interesting back and forth about the usefulness of tradition and sort of history with a lowercase h, not founding era history, but just kind of the way things have gone. And I think, the court has been in many areas of the law, the Second Amendment most notably, trying to interject more and more of that approach to deciding cases. And I thought it was so interesting to have Justice Barrett. I think, if I'm remembering, is this the case I'm remembering, where Justice Barrett says, just because we've done something for a while doesn't mean that that's what the law requires, that we may have been doing it for reasons that had nothing to do with the law. And that's the first time I've seen her stake out a different position than, say, Justice Kavanaugh or Justice, for example, who seems more willing to say, look, if I see that going on in history, I'm just going to follow it. And it doesn't require nearly kind of proof that everybody thought they were doing it because of some legal requirement. So there's kind of a different way to take that into consideration, which I thought was really interesting in that case.
Well, that brings us to, one of the biggest pieces of the Trump agenda, which is the birthright citizenship case, where both Justice Alito and Justice Kavanaugh are doing this kind of living constitutionalism point, in a way, if you think about it, which is they say, oh, sure, At the time of Wong Kim Ark, there was just this limited group of exceptions to birthright citizenship. But times have changed, and we ought to be thinking more broadly about, now we have all of this unwanted immigration into the United States, and we have people who can get on planes and yada yada. And it was kind of fascinating to see that and the
Yep.
Second Amendment, and then the Second Amendment Hawaii case. And how do you want to use the Reconstruction era history
Yeah.
that's bad history in the sense that we no longer agree with those positions. I think you're right that this history and tradition stuff is so plastic.
Well, I think that the birthright divide amongst the court members was really particularly interesting in that way. Like, I'm not sure if I would think Justice Alito and Kavanaugh would really say they're originalists, at least not to the level of some of their other colleagues. And interestingly, Justice Gorsuch, who dissented on temporary visitors, would have agreed with the plaintiffs as to, and did agree with the
Yeah.
plaintiff as to people who are here unlawfully and have and children. And so he kind of peeled off exactly on that point from an originalist perspective. So I thought that was quite interesting and noteworthy as well.
Yeah, I just, watching how the justices use history now, it just seems like it's becoming more and more of a fig leaf.
Yeah, I mean, I think that I was thinking about this more generally today when I read some of the other cases too, and that we have some cases where the court still does this sort of traditional strict scrutiny or some other forms of means ends testing where they walk through, we have a potential constitutional problem here, so let's see if the government has a good enough reason for what it's doing and if there's some other way to do it without impinging on constitutional values. And that's kind of the traditional two-step. And the thing that strikes me about that, maybe this is getting at your point, Pam, is even lay people can read those decisions and hear them reported and kind of get a pretty quick sense of whether they agree or disagree with the court's reasoning. I mean, it's kind of
Yeah.
transparent in that sense. It's like the values that are driving those decisions are kind of laid out for the public. They're not pure policy values, but they're legal values that have that kind of a flavor to it. But when you do these battles about history and tradition, and about whether Rhode Island in 1822 had this kind of law, or New York and 1850 had some other kind of law, and how you sort of relate that law, whether it was enforced or not, to the kind of law you have now. The public's kind of left on the sidelines, like with no real way to judge who's right or who's wrong about these debates. And I guess if that's really what's driving the debate for some justices and they really feel strongly about it, I'll give them a little bit of slack. But I don't think that's true all the way down the line. And some of the justices are using history and tradition kind of as a portal into policy analysis, like means end scrutiny. And there, I think there's a real problem because it's just not as transparent to the public and to anyone else who cares about the law, what the court's really doing and why they're doing it.
So one place where the Trump agenda and the conservative agenda really met, I think, is in Trump against Slaughter, which is the case about whether the president can fire for any reason or no reason at all commissioners on these major so-called independent agencies, things like the Federal Trade Commission, the Federal Communication Commission, National Labor Relations Board, and the like. And there, I think it was predictable. We sort of knew what was coming because the court had chipped away for years at the Humphreys executor argument. But the court decided that case, and then the same day came down with a decision essentially saying that Lisa Cook, who's a governor on the Federal Reserve Board, could stay in her position unless and until the president was able to fire her for cause. What do you make of the unitary executive theory, and how far down do you think it goes? That is, the way the case is written, it's about, well, of course, the president has to be able to fire the commissioners on the EEOC. But how far down does the unitary executive theory go in the president's ability to fire people in the executive branch and in these agencies, do you think?
Great question. Let me say a couple things before I get to that. One is I should just sort of say for the listeners that our clinic did a brief in that case. So I supervised a group of students, and we worked with members of Congress to, in a sense, defend Congress's law and the FTC Act and others that were at issue there since the Trump administration, which would usually defend a law of Congress, was actually attacking it. So we had a dog in the fight,
Yeah.
just to be clear. But I think the couple of things about that decision that I found troubling. One is that this was a stare decisis case. In other words, should the court overrule precedent? So the court had looked at this question before and unanimously come out the other way. And even during this more recent revolution you described, Pam, Chief Justice Roberts admitted that the Constitution was silent on the president's removal power. So it's kind of a structural interstices kind of argument. And in that kind of a scenario, boy, you'd think the court would have a little more respect for the prior views of not just the Supreme Court, but of the political branches over the years of reaching this, you might think of it as a compromise, and just letting the political process take care of this problem as it might. It's a very, very muscular use of the court's power that we saw in this case. The second thing is when you talk about Lisa Cook, that brings me back to the point I was just making a moment ago, which is it's hard for me to understand, and I'm not alone here. Justices Thomas and Barrett said the same thing, how the Fed can be any different from all these other independent agencies. The court waived a couple paragraphs of history of the first and second United States Bank of the United States, which give a sort of rough analogy, but boy, that's a long way from a carve out to
Yeah.
a passionate as the court
Yeah.
thought that again, it had to overrule precedent to announce, and everything else in the opinion sure seems at odds with that. So you just get the whiff of the sense that the court is thinking again on policy grounds that the feds ought to be treated differently, not on constitutional
It comes
grounds.
pretty close to saying it's policy grounds when they talk about the importance of the perception of independence and the
Yeah.
like, which just doesn't seem all that different, at least to me, doesn't seem all that different for the Fed and for, say, the Merit System Protection Board.
Right. There's any number of
Yeah.
other nuclear energy or, as you said, communications and media or any other number of regulatory areas where you might think independence is enormously important. And it just becomes, I think, a value judgment as how that stacks up against monetary policy. So yes, I find that very frustrating. Can I cheat a little bit, Pam, and say, like,
Absolutely.
I don't know. I'm guessing you have thought more than I have about how far this goes down to, non-principal officials, given your time in the
Yeah.
government. So I'd be really interested to hear your view on that.
Yeah, I mean, I have the view on that that's a little bit like your point about Justice Thomas and Justice Barrett's saying we don't exactly see all this big difference between the Fed and which is
Yeah.
I don't see all this much difference between the principal officers who are nominated by the president in the first place. And the Constitution does have stuff in the appointments clause about whether those people have to be appointed by the president or can be nominated by
Yeah.
heads of departments or the like. I don't see a principled explanation for why civil servants are entitled to protection if you have a really muscular version of the unitary executive, because it's not as if when the president tells like the head of the FCC to block a merger between, or the FTC to block a merger between two communications companies, that the only person who's involved in blocking that is the commissioner. There are all of these lawyers below that, and the person who writes the checks, and the person.
Yeah.
And so I do kind of wonder if you take the unitary executive theory as seriously as some of the members of the court seem to think you have to, why the president isn't entitled to fire assistant U.S. attorneys and
Right.
fire, staff lawyers at the FCC and the like, as well as the people at the top. And yet I have this sense the court doesn't think that the civil service is unconstitutional.
I don't know. I
And
mean,
I can't
I'm
figure out why.
fascinated because in some ways you think it's even more perverse for some, underling to be able to thwart the president's power. President Trump used to complain about the deep state. That seems even more perverse than letting somebody with, maybe approved by Congress or the like, speak up and do
Yeah.
something.
Yeah. So I do kind of wonder about where we end up how far down the unitary executive goes. I mean, certainly Donald Trump is attempting to do a bunch of stuff there with the schedule, I think Schedule F or whatever it is, to change a number of people who are currently civil servants who are protected by for cause removal into people who can be fired
Yeah.
by an administration at will. We haven't mentioned all of
Can I
the,
say one other
yeah,
thing about that? I
absolutely.
wonder
Yeah.
whether you mentioned the break, not break the court gets over the summer now. I wonder whether this could be a area of a lot of shadow docket energy very, very quickly if Trump starts firing a lot of people. I think that's just something to watch.
Yeah, I think that's right. That, I think the Supreme Court has emboldened him.
Yeah.
I think the cases we've talked about have emboldened him. The immigration cases, which we haven't discussed, emboldened him. The temporary protective status case in particular. I mean, I thought it was really, I have to say, I thought that case was particularly shocking in some ways because Justice Alito's opinion for the court just completely sidelines the fact that Donald Trump made one racist comment after the next about Haitians who are in this country on temporary protected status. They eat dogs that poison the blood of the country. You know, they come from a shithole nation and everything. Why can't we have more Norwegians and Swedes? And it was almost as if, he said, let's just talk. And yet, whenever he sees even the slightest criticism of culturally conservative religious people, he sees bigotry of a kind that the court has to race in to stop.
I can't improve on that point. I think it's odd to me as well how some members of the court, whether they call it giving him the benefit of the doubt or airbrushing over potentially, very, very serious comments. I don't quite understand it either. I think there's two things that the court hasn't figured out, at least many members of the court haven't figured out what to do in the Trump era. One is what to do with these tweets and bombastic, sort of informal, offhand, but very provocative remarks that the president makes, sometimes on almost a daily basis, because it's just so unprecedented from a US president. And similarly, I think the court has been struggling to figure out what to do about certain positions and representations the Trump administration makes in certain cases, essentially saying black is white, or the sun, sets in the morning and rises in the evening. And the Trump administration has made the argument a few times, well, if the president decrees a certain fact, you can't look behind it, for example, and some of these
Yeah.
immigration disputes and the like. And I think the court is just, again, puzzled and struggling with what, if anything, to do about that. And probably if push comes to shove, they would have very different views, as we saw in the case in the Haitians case.
Yeah, it is striking. I mean, and this goes back even to Trump one and the Hawaii, Trump v. Hawaii and the Muslim ban, or the irregularity in the census case in Trump one. But
Yep.
this time around, I think it's even more striking. I mean, I thought the apotheosis of this in some sense, and the Chief Justice gives this the back of his hand in the Lisa Cook case, is saying Lisa Cook received notice and an opportunity to be heard because the president tweeted that she was going to be fired for this mortgage stuff, and she didn't do anything about the tweet. I mean, do you remember that argument? Which I
Oh,
thought
that's the argument.
that was
Yes.
meant,
Right.
and
Yeah.
and the Chief Justice kind of gives that the back of his hand. No,
Right.
that's not, that's not. But the fact that you can get the Solicitor General of the United States up there to argue that just is really striking. And I think, we're gonna see more of this because as you said about the kind of summer, I think Donald Trump is going to come out of this term slightly chastised, but remarkably emboldened by the Supreme Court. That is, he didn't get everything he wanted.
Yeah.
He got nailed on two of his signature policies, the tariffs early on in the term, and then birthright citizenship. But in terms of his ability to do what he wants, as opposed to have a policy in there, he
Yeah.
got most of what he.
I think that may well, I mean, we're starting to talk about politics a little bit more than law, which I'm not an expert in, but I wouldn't at all be surprised if you're kind of right and then some. I mean, if you would have both on tariffs and Lisa Cook, the court said, no, not this way, but maybe some other way. So they left him plenty of running room to at least try other
Yeah.
things, which may or may not succeed. And on birthright citizenship, he's, I guess, as of this morning, arguing for Congress to pass a law, which is what Justice Kavanaugh would have opened the door to let happen. Now, 5 members of the court have voted, that the Constitution would stand in the way of a new law. But maybe that, again, maybe President Trump isn't that unhappy with that result because it gives him a jawbone opportunity. And boy, he's one vote away on the court, perhaps, at least to partially getting what he wants. And he's got a good political issue in the meantime. I don't know. I
Yeah.
wonder. Yeah.
So any other cases that you want to bring up from this term?
Actually, yeah, let me bring up a case I'm curious to get your reaction to, which is the transgender athlete case
Yeah.
today. Transgender rights is an area where the court has been active lately. And the way the court decides the case is to say that state laws that ban transgender girls from participating on girl sports teams is because, at least the way I read it, is because distinctions based on sex are subject only to intermediate scrutiny, not the strict scrutiny. And so, therefore, even if you have some transgender girls that have none of the advantages that the states are generally concerned about, that's okay because the fit doesn't have to be as tight as it would have to be if you were dealing with something like race discrimination or maybe religious discrimination. And I wonder, boy, that's again a bit of a swerve, if not a U-turn, as Justice Sotomayor points out in her dissent from where Justice Ginsburg had been leading the court for many years to really, really. I remember having an oral
Yeah.
argument one time where she pointed out to me at the podium how sex discrimination and race discrimination were viewed almost identically these days by the court, and I wonder whether we come out of this case not just whatever the implications are for transgender people, which are obviously serious, but more generally, I wonder if you think this signals a bigger change in how the court approaches sex discrimination.
So I don't know that I do. And part of the reason is that athletics was treated differently in Title IX than almost anything else. That
Yep.
is, if you think about Title IX, it says you can't discriminate on the basis of sex in any educational institution that receives federal funds, which is every public K through 12 school in the country and all but about 5 universities or colleges in the country. But they've always allowed, as part of the statute itself, you know, single sex dorms, single sex bathrooms, single sex athletic teams. And if you think about Title IX is the reason why we have
Right.
girls and women's athletic teams
Do
getting.
you think that kind of informs
And I
how we
think
understand the
that is,
Constitution too?
I would have thought, like, for example, if this had been a case not about athletics, but had been a case about, a school where a middle school, say, where the boys all go to shop class and the girls go to home ec class, and they say a transgender girl cannot do home ec, she has to do
Uh-huh.
shop.
Uh-huh.
I think the court would have come out the other way.
Interesting.
And I think some of what's going on here is this notion that the entire point of women's sports is to give women an opportunity to play sports that they would not have if you simply said we're going to have 2 basketball teams or
See.
we're going to have 2 volleyball teams. That what you'd have is one team of all men and then another team of all men. And I think that is a lot of what was driving the court here,
Mm-hmm.
because the court, the court came out 6-3 the other way in Bostock on, can you discriminate in employment, in just saying I'm
Right.
not going to hire a transgender
Right.
woman to be a funeral
Right.
home director or the like. And so I wonder how much
Okay.
the sports nature of this.
I think that's a great point. Yeah.
But
Justice Gorsuch points this out in his concurrence, I guess it is.
yeah,
And
after saying
interestingly,
not one word at oral arguments
I know,
about any
but he
of
does
this.
make the
Yeah,
distinction, as the
yeah,
author of Bostock makes
yeah,
the
as the author
distinction
of
that you're
Bostock,
you're
that I do
describing. And
think,
and Justice Kavanaugh, as
as
kind of a
girls
sports lover
basketball
on the
coach,
court, yeah,
yeah,
would have
yeah, as girls basketball team coach,
yeah.
has this notion that, this is about protecting girls' ability to play sports. I do think going forward that you're gonna see some spillover from this, and
Hmm.
because you're gonna have again, things like bathrooms and the Gavin
Yeah.
Grimm case that you may remember from a couple of years back.
Yeah.
So
But your point reminds me of something we talk about in the clinic a lot, which is sometimes the court speaks in seemingly sweeping ways, but you have to contextualize everything that you're hearing. Both, which sometimes makes it bigger and sometimes makes it smaller, but you always have to remember the context. Yeah.
yeah, and the other context, of course, is that we've had this backlash again in the political process against transgender folks
Yep.
recently,
Yep.
and that may be playing out here as well. So I want to thank you, Jeff, for, I mean, I guess one good thing about the fact that the court, two good things about the fact that the court decides so few cases on the merits now is we can get through almost all of the big ones in a single sitting, and they do less damage than they might otherwise do. So I want to thank our guest today, Jeff Fisher, for coming on the show. This is Stanford Legal. If you're enjoying the show, please tell a friend and leave us a rating or review on your favorite podcast app. Your feedback improves the show, and it helps new listeners to discover us. I'm Pam Karlan. See you next time.